Hello everyone. I'm going to speak on issues specific to the internet and something called as the ACTA in United States. To begin with the summary, I'll go through on what ACTA is, introduction to the formation of ACTA, the main differences between TRIPS and ACTA, enforcement of intellectual property rights in a digital domain, internationalization of Section 512 or the US copyright laws and ACTA, DMCA versus fair use, and at the end, how do all these matter to us? Now, to begin with, on what ACTA is, or the Anti-Counterfeiting Trade Agreement, it's basically to establish a competent international framework in protecting owners of intellectual property rights and obviously combating piracy and counterfeiting issues in the 21st century. The agreement seeks to toughen IP flow globally through international cooperation amongst various governments and protect innovation and creative works against intellectual property theft, or basically to promote something called as the progress of science under the US Constitution. And because ACTA is to protect intellectual property rights of owners, cooperation amongst ACTA parties to address challenges of cross-border trade in counterfeit and pirated goods is a primary concern, and basically it is set to enforce best practices that can be used by legal authorities of the respective parties, aims to define effective procedures for enforcing existing intellectual property rights of that particular country. If you look at how ACTA gets into formation, it's mainly as a treaty that has been signed independently by negotiations with different nations, as stated here: Australia, Canada, the European Union, and they signed this treaty separately away from the control of WIPO and WTO, because it's clearly understood that any development process via WTO is going to take a lot of time and to get ACTA into action, and hence Professor Michael Guest of the University of Ottawa says that in the 2006 side meetings of WTO, the formation of ACTA was discussed, way before 2008. So this leads us to the fact that TRIPS and ACTA are actually same, but they set completely different standards. TRIPS was the intellectual property rights set in 1994 to protect creative work of authors, and due to dramatic changes in technology, we have an improved benchmark which is otherwise called ACTA to combat piracy issues and IPR infringements from technologies we have today, like P2P networks. Obviously, the origin of such networks took place in the 90s, but the laws couldn't keep up with the dynamic technological changes, and hence ACTA gets into provision. ACTA supersedes TRIPS, in specific areas like border measures across international countries, civil enforcement, and also enforcing criminal punishments on infringing copyrighted or intellectual property materials, and basically setting IPR on internet. So the enforcement of IPR in the digital domain, which I mainly focus on, is on Section 5 Articles 21.7 through 27.6, and what's interesting about these articles mainly is to observe that they are similar to the provisions that are set in the US statutes, meaning that the provisions of ACTA and US statutes look similar and or go parallelly, which I feel is controversial. USTR, or the Office of United States Trade Representative, which is an executive body under the which is governed by President Barack Obama's office, addresses concerns of Senators Bernard Sanders and Sherrod Brown on ACTA, and they implicitly state that they're using the Digital Millennium Copyright Act as a reference in crafting the Section 5 provisions of ACTA, meaning that they're dependent on DMCA. Also mentioned in this letter is that they were seeking incentives similar to Section 512, and we are not seeking any obligations that go beyond US law, meaning that they're using US law as the basic framework. Yeah. For example, if you're looking at this huge Article 27.4, but I rather focus on particular words here. If you're looking at terms like legally sufficient claim in ACTA's 27.4 article and a sworn declaration in Title 17, Section 512, so obviously this is an open question. It remains on what do you mean by legally sufficient claim. Obviously both of them, they look similar, but in a way they are contradicting or each other, and they're not they're not giving a clear opinion on how legislation should be crafted to protect owners of copyright. And that is the first issue. And the second issue here would be between the DMCA and ACTA versus fair use. If you're looking at ACTA, as I stated before, that the USTR clearly say that they're using DMCA as the basic framework to develop the rules in ACTA, and they are crafting rules of anti-circumvention provisions or technological protection measures, or otherwise called as TPMs. This is an anti-innovation approach, towards technology, and which obviously conflicts with Section 8 of the U.S. Constitution, which says to promote the progress of science. So the anti-circumvention provisions seem to be similar to what are stated in the DMCA, and because it's clear that they're using DMCA as a basic framework, they're internationalizing these laws globally onto other countries as well. And fair use is the biggest argument against DMCA, one could claim, because there is no exemption for fair use of copyrighted work under the provision of DMCA. It does not look fair to approach in setting global protection standards for IPR on other countries when in US you have no exemption for fair use under the DMCA. So obviously I feel that there are some kind of conflicting issues here, and hence internationalizing this is to me not a fair approach. I discuss at length in my written paper about these issues. At the end, how do these things matter to us? We should focus on two questions here, mainly on why the Digital Millennium Copyright Act is a bad idea, and how internationalizing ACTA through DMCA impacts legislation globally. As I stated before, Professor Michael Guest from the University of Ottawa addresses that ACTA is better off as a treaty implemented independently from the likes of the functioning of WIPO and WTO, as I stated earlier, that it was found independently, away from the control of the World Trade Organization and the World Intellectual Property Rights Organization. This is mainly because to speed to fast track the process of ACTA, and countries involved in ACTA not recognized for originating piracy, like obviously it's United States, England, where it's not genuinely known for large scale piracy distributions. As such, these countries were the main part of ACTA, while the countries where piracy is at large were not the part of this treaty. Other countries who were not involved with ACTA in future might be obligated to follow provisions of ACTA. So this again brings up controversy, mainly because of the non-involvement of developing countries in this provision, and they might later be obligated to follow the provisions of ACTA. And these issues are these issues form the core of my paper, and I tend to address at length on what these state.